as 5 field agents and 2 crime scene specialists.
All right. Tell the judge a little bit about your training and experience in the field of law enforcement.
Okay. I've been employed with the GBI since 2011. In that time, I have worked drug investigations as well as what we'll call field investigations, or mostly violent crime, and also officer-involved shootings. In that time, I've received training on all general laws and procedures, as well as how to effect arrest and how to conduct investigations.
And are you a post-certified law enforcement officer?
Yes, ma'am, I am.
And have you had experience in interviewing suspects, witnesses for crimes?
Yes, ma'am, I have.
Have you taken any post-specific training in that field?
Yes, ma'am. Of course, there's the general training, 8 hours that you get when you're in mandate. There is a 40-hour class that you receive in GBI Basic Agent Academy. There's also the read interviews and interrogations training that I believe was 4 days long. I've also attended some other interviews and interrogations trainings on my own that I found.
Right. So, directing your attention to the investigation into the death of Ahmaud Arbery, were you involved in that investigation?
Yes, ma'am, I was.
Tell the court how you were involved in that investigation.
I was asked to assist Region 14 in the investigation. I came down the morning that we were first brought into the investigation to assist us, ASAC Richard Dial, in the investigation.
And would that be approximately May 5th of 2020?
I believe so. It was the morning after it was announced that we had been requested.
Okay, so the 5th or the 6th?
Yes, ma'am.
So I'm going to direct your attention now specifically to the time between May 6th and May 11th. Did you have any contact with Defendant Bryan?
Yes, ma'am, I did.
All right, tell the court about that.
Initially, myself and another agent went to his residence and made contact with him there, just advising him that we'd like to have an interview with him. At that time, he told me he was trying to locate an attorney, and then once he had done that, he would reach back out to me.
Okay, and was this just sort of a friendly conversation?
Yes, ma'am.
Cooperative conversation?
Yes, ma'am.
Any threats made to him that he had to talk to you?
No, ma'am.
Any promises that if he talked to you, something good would happen or charges wouldn't be brought?
No, ma'am.
All right. And at that time, did you force him to speak with you?
No, ma'am.
How long was that conversation?
Approximately 5 minutes.
And was it recorded?
Yes, ma'am.
After that conversation, did he make contact with you or did you contact him again?
If I remember correctly, he contacted me. I had left my business card with him.
And when he contacted you, what was the purpose for the contact?
To arrange an interview.
And did you then arrange an interview with him?
Yes, ma'am.
At any point in time, did you have contact solely with him or with another person as well?
Primarily after that, it was through his attorney, Kevin Goff.
Okay. And I'm going to ask you for the record, if it helps to stand up, do you see Defendant Bryan in court today?
Yes, ma'am.
Okay, and what color shirt is he wearing?
I believe it was white. He's sitting to the left of Attorney Goff.
And you also see Mr. Goff in court?
Yes, ma'am.
All right. Please let the record reflect that he's identified both Mr. Bryan and Mr. Goff. So after this, you start having conversations with his attorney. Is that
That's
correct? Okay. And who initiates most of these conversations with his attorney?
Primarily Mr. Goff.
Okay, so he's calling you.
Yes, ma'am.
All right. And when he's calling you, what is he saying to you?
He's very concerned about the media narrative that's being pushed out about his client. He's very adamant that his client can be a witness for the state and that he has information that we will want to hear.
Do you control the media?
No, ma'am.
Okay, so there's absolutely nothing you could do about what the media is saying about this case.
That's correct.
What did you want to do as far as Mr. Bryan goes?
I wanted to get his statement.
All right. And what did Mr. Goff want?
Objection. He can testify to what he's observed or knows, but he can't testify with someone else's mind.
That's the statement.
What did Mr. Goff tell you he wanted?
Mr. Goff was advising me that he wanted some kind of, I guess, proclamation or acknowledgement from the GBI that his client was cooperating.
Okay. And Is that something you promised him?
No, ma'am.
Now, between the time you first made contact with Mr. Goff and the time of the May 11th, 2020 interview, did you make any promises that you considered Mr. Bryan to be someone that wouldn't be indicted? In other words, did you make any promises to Mr. Goff about charges, arrests, or indictments as far as his client went?
No, ma'am.
Did you ever say to Mr. Goff that Mr. Bryan was not a target of the investigation?
No, ma'am.
Is target a word you usually use?
Not normally.
Okay. Did you at any time assure Mr. Goff that when the interviews with Mr. Bryan were finished that the GBI was going to make a public statement and issue a press release?
No, ma'am.
All right, so we're going to go forward then to that time between May 11th and May 13th. Any sort of promises about if you cooperate, you make another statement to me on May 13th about charges, arrests, indictments?
No, ma'am.
Any promises at all? Any benefit to Mr. Bryan for coming in a second time on May 13th to talk with you?
No, ma'am.
On May 13th, did you intend to arrest Mr. Bryan?
No, ma'am.
So on May 11th, he wasn't under arrest when he came in and spoke with you with his attorney.
That's correct.
On May 13th, when he came in and agreed to speak with you with his attorney, was he placed under arrest?
No, ma'am, he was not.
Did he leave the building freely and voluntarily?
Yes, ma'am, he did.
And did he actually go with you and Mr. Goff on a drive-through of the neighborhood?
That's correct.
And were all those recorded?
Yes, ma'am.
So, have you had the chance to review the 2 transcripts as well as the 3 audio recordings of both, first the May 11th, 2020 interview, the May 13th, 2020 interview at the office, and then the May 13th, 2020 drive-through?
The 2 transcripts I reviewed, all of the audio recordings I have reviewed at some point in time since the actual interviews occurred.
Okay. Did you do anything to delete anything out of any of those audio recordings?
No, ma'am.
Do anything to modify or change them?
No, ma'am.
All right. And did you hand them over as part of your case file to Special Agent Dial?
They were uploaded to our digital case management system as recordings to my reports.
Okay. Your Honor, at this time, the state will tender into evidence State's Exhibit 53, which is going to be Mr. Bryan's interview from May 11th, 2020. It is in audio format. And if I may have one moment, Your Honor, it appears that our evidence is now not on the reminder board. We have now found the evidence. And that was an audio recording from May 11th, 2020, is that correct?
That's correct.
Okay, and Mr. Goff, you can see right here we have in folder State's Exhibit 53, that particular audio recording. At this time, the state will tender State's Exhibit 53.
Any objection?
Not for purposes of this hearing.
Then we have State's Exhibit 54. Once again, about an hour and 15-minute audio recording, is that correct?
For which interview?
The second interview, the first interview on May 13th.
That sounds about correct.
All right, and you reviewed the transcript for accuracy.
Yes, ma'am.
All right, this time the state would tender into evidence State's Exhibit 54, which is the actual audio recording of the May 13th, 2020 first portion of the interview. And then we have 54A, which is the transcript.
Any objection?
No objection for purposes of this hearing.
at State's Exhibit number 55, and that would be driving in the car.
Yes, ma'am.
And were you able to review that transcript?
Yes, ma'am.
Was it fair and accurate?
It was.
At this time, the state would tender into evidence State's Exhibit 55, which is the actual audio interview with Mr. Bryan for the drive-through, as well as the transcript of the statements made during that drive-through, which would be labeled as 55A.
No objection for purposes of this hearing.
Admitted.
Thank you. At any time during any of these 3 interviews, did you make any promises to Mr. Bryan or to his attorney about charges that would be brought against him?
No, ma'am.
Did you make any promises about charges or indictments to him?
No, ma'am.
Did you make any statements to him or to his attorney that the GBI was going to release any sort of press release or anything to assure that the public knew about his cooperation with you?
No, ma'am.
Was that something Mr. Goff wanted?
That's correct.
Now, because Mr. Goff came up to you and asked you for these things, does that mean you agreed to them?
It does not.
After the interviews on May 13th, did you continue to have interaction with Mr. Goff?
Yes, ma'am.
Okay. Mr. Goff, in his motion, alleges something about meeting at a Starbucks. Could you tell the court what happened in that incident?
Yes, ma'am. I believe that might have been the May 13th timeframe, if I remember correctly, or shortly thereafter. And we had we had planned on meeting and having a conversation, and it did revolve around his wanting a press release, at which I advised I don't control, but that I can speak with people at my chain of command for. At that time, when I tried to connect with him, was when he advised that there was a large crowd of press outside of his house. So to avoid a scene or any type of just chaos around that, we agreed to meet at another location. I'm unfamiliar with St. Simon's, and I believe he was the one that offered the Starbucks nearby his house.
Okay. And were you actually able to make that meeting at the Starbucks with him?
No, ma'am.
Okay. Why not?
After discussion with our investigative team, we decided it would be better not to have that meeting.
Okay. Because you're under no obligation to put out any press release at all, right?
That's correct.
All right. At any point in time, since your first interaction with Mr. Bryan at his home, where you first approached him for the 5-minute conversation, all the way through your interactions with him and Mr. Goff, did you threaten Mr. Bryan in any way, shape, or form?
No, ma'am.
Did you threaten his family members or any financial harm to him at all?
No, ma'am.
And at the very beginning of the first May 13th interview, did you specifically address Mr. Bryan?
Yes, ma'am.
What did you tell Mr. Bryan at the very beginning of that interview on May 13th, 2020?
I reminded him that this was a voluntary interview, that he was not obligated to talk to me. Even though that his attorney was there with him, I wanted to be sure that he understood that.
And was Mr. Goff present during the entire May 13th interview, both of them?
Yes, ma'am.
And with regard to the May 11th interview, that was about 2 hours long, was Mr. Goff also present during that interview?
Yes, ma'am.
And during both those time frames and the time frame in between, who was, I'll put it this way, was Mr. Goff attempting to elicit promises from you about the status for Mr. Bryan?
Yes, ma'am.
Were you offering any status to Mr. Bryan?
No, ma'am.
In your opinion as a law enforcement officer, were Mr. Bryan's statements freely and voluntarily made to you?
Yes, ma'am.
And his attorney was present during everything?
That's correct.
Did you in any way attempt to induce him to talk to you, coerce him into talking to you by making threats or promises?
No, ma'am.
I'll pass the witness. Thank you.
Mr. Goff.
Good afternoon, sir.
Good afternoon.
Seems we both have more gray hair than the last time we met.
I think so.
I'm going to start off by asking a few questions about the climate surrounding these interviews on May 11th and May 13th. On what day were the McMichaels arrested?
I don't remember the exact day. It would have been a few days after the GBI was first requested.
And the week before these interviews took place?
I believe so, yes, sir.
Okay. And I believe in your interview, I don't have the transcript references, but I have the timestamp references. You acknowledged in the interview, it's as close to a quotation as I can manage here, it's been a very trying time, even over the past couple days, a difficult time. Do you remember those words?
Yes, sir.
Okay. What did you mean by that?
The climate in the community was very difficult. There had been an influx of media. There had been not just media, but also protesters that had come to the city and had specifically also come to the neighborhood. There was a lot of calls for how to handle the McMichaels and Mr. Bryan. There was just a lot of tension.
All right, to be more specific, had there been at least one, if not more, organized protests, including a march through the neighborhood in the days before Mr. Bryan spoke with you? I mean Mr. Bryan's own neighborhood.
Yes.
Okay. And I think do we have the audio or the video tendered for the driving the car? Or both? We have both, do we not?
We only have the audio. Due to the limitations of technology, the videos were too large to place on the jump drive, so it's simply the audio files.
All right. Well, we don't have the audio. We're not playing the audio today, the video anyway, but you recall an unusual number of people that didn't seem to be part of the community in the neighborhood of Satilla Shores while you were escorting Mr. Bryan around the neighborhood?
I do remember there being some people that appeared to be just out. Yes, sir.
Okay. And do you remember a conversation, unrecorded conversation, with Mr. Bryan and his fiance and I about the news crews in an incident reported that day or the day before, a news crew reporting that shots had been fired in the neighborhood?
I don't recall that specifically.
Okay. Do you recall a discussion of the news crews being afraid to be in the neighborhood?
Not specifically. I do remember one news crew, a discussion, and I don't remember if it was you or someone else, but a discussion about a news crew with security teams with them. That's probably as specific as I remember regarding that.
Do you remember a conversation about individuals portraying themselves as being media and trying to talk to the neighbors?
I'm going to object at this point in time. Do you remember individuals? Which individuals are we talking about? What hearsay are we talking about? And also relevancy as to the voluntariness of the statement.
I'm sorry. I have the witness on cross, and I can leave. But I'll rephrase the question.
Yeah, I don't have a problem with that. You can continue. I assume this is going to a point, so I'll
Yeah.
allow you a thorough and sifting cross-examination someplace.
Fair enough. Mr. Bryan and his fiance constantly expressed to you their concerns for their own personal safety. Did they not?
They did.
And they discussed the reports, whether they're true or not, of the news crews being afraid or prohibited from coming in the neighborhood or bringing security with them. They discussed this with you, whether it was true or not. Did Roddy Bryan and his fiancee, Amy Elrod, discuss between May 11th and May 13th on multiple occasions incidents that gave them concern for their personal safety?
Yes.
Okay. Including the fact that a news crew reported being shot at and that other news crews were bringing security?
Again, I don't remember that conversation specifically, but there was conversations about trouble in the neighborhood or potential trouble in the neighborhood.
All right. Would it be fair to describe this in this time period from May 11th to May 13th as a neighborhood on edge?
It would be fair.
Okay. Did Mr. Bryan and his fiancee, Amy Elrod, express to you in this time period concern over someone trying to run them off the road on the interstate when they were on their way to see the polygraph examiner that they consulted in this case?
I remember you and I discussing it. I don't remember specifically if Mr. Bryan and Ms. Elrod and I discussed.
Do you remember Roddy and his fiancee Amy Elrod expressing fear of living in their home in Satilla Shores?
Again, I remember conversations with you about wanting them to get out of town for their safety. I remember general conversations with Mr. Bryan and Mrs. Elrod about their safety, but as to the specifics, I don't recall.
Okay, well, very good. Do you recall Amy Elrod walking up to you on the afternoon of May 13th and giving you a letter, a threatening letter, that was in her mailbox at her house in Satilla Shores where she and Mr. Bryan lived?
Yes, sir, I do.
Do you recall she and Mr. Bryan asking what the GBI could do to help protect them?
I don't remember that question specifically. I remember the letter being given to me or given to me or another agent, but I don't remember a specific question other than concern because it was in her mailbox.
You don't recall them asking you what you or the GBI could do to arrange for their security?
Again, I don't remember the specific conversation. I remember receiving the letter and I remember passing it to another local agent.
Okay. Do you recall Mr. Bryan specifically between May 11th and May 13th being concerned for his physical safety?
Yes.
Okay. And in fact, he had reason to be concerned for his physical safety, did he not?
That would be for him to answer. Again, there was tension in the neighborhood. There was a lot of calls in the media. As to his particular experience and what he was seeing out in town, I wasn't with him during those times.
Fair enough. Now, aside from these recorded interviews, you had unrecorded interviews with Ronnie Bryan and Amy Elrod.
I don't recall unrecorded interviews. There were conversations for like logistics and those kind of things, but anything of substance that would call an interview would have been recorded.
Because that would be policy, right?
Our policy has leeway, but primarily we would try to record all those interviews.
Fair enough. Do you recall having unrecorded conversations with Mr. Bryan and I outside in the hallway at the DNR headquarters, outside the room where these formal interviews were taken?
Yes.
Okay. Do you recall having conversations with Mr. Bryan and or myself outside on the front steps of the DNR building?
I do recall.
Do you recall other conversations outside in the parking lot with Mr. Bryan, at times Amy Elrod, about this case?
There were multiple conversations before and after the interviews, again, about logistics and different things that were going on. Yes, sir.
And specifically, you called and you said you needed Mr. Bryan to come down to the Glynn County Detention Center, did you not?
For what purpose?
Do you recall asking Mr. Bryan and Amy Elrod to meet you at the Glynn County Detention Center in connection with getting fingerprints?
I believe that was at the hospital.
At the hospital? Okay.
Yes, sir. But yes, that's correct. They rode me down to the detention center.
All right. And y'all had conversations inside the car?
Conversational in nature.
Okay. By the way, is your vehicle equipped? I think did you have the same vehicle from May 11th to May 13th?
Yes, sir, I did.
Is that vehicle equipped with a recording device?
No, sir.
Okay. Your cell phone is capable of recording, is it not?
It is.
Did you record any of those conversations?
No, sir.
Okay. And while you were in the car from the hospital down to the detention center, and while you were at the detention center, you didn't record any of those conversations?
No, sir.
Okay. And before that, after the second interview on May 13th, you went out to Mr. Bryan's house, did you not? I think you've acknowledged that you were out there.
Yes, sir.
And you were invited inside their house, were you not?
That's correct.
And you and perhaps another agent were inside that house for some time, were you not?
That's correct.
Okay. And again, there were conversations at that time with Mr. Bryan and his fiancée.
Yes, sir.
Okay. And while they weren't necessarily formal interviews, you were discussing with them how to obtain various kinds of evidence from the house. Were
That's
you not?
correct.
Okay.
They had provided on consent. Yes, sir.
All right. Did you record any of those conversations inside the Bryan residence?
No, sir.
Okay. Now, directing your attention to the what I sometimes call the path of travel video, some people would call a reenactment video, when you're driving Mr. Bryan around the neighborhood. Who was in the car at that time?
I was driving. Mr. Bryan was in the front passenger seat. I believe you were in the back passenger side seat, and then another GBI agent was in the back seat. Actually, I might have that reversed. You might have been sitting behind me. Maybe the agent was sitting in the back side passenger.
Fair enough. And the video that has been tendered by the state, was that recorded by the truck itself?
No, sir.
Again, does the truck have its own recording device?
No, sir.
No, sir. Okay. Were you independently wearing a body cam at that time?
No, sir.
The other officer?
No, sir.
Okay. Were you or the other officer using your cell phones to record these conversations?
No, sir.
Okay. Because you would agree that the video that has been tendered in evidence in this case, in the transcript, does not reflect the full conversation.
It reflects from the time that we started the reenactment.
But that's, okay. But that's not really true, is it?
That's true.
Okay. How many times did you drive Mr. Bryan around the neighborhood before you turned the camera on?
I don't recall driving him around the neighborhood before we turned the camera on. Not to my recollection.
You don't recall driving about and then going back and starting over again a second time?
Without looking at my report, I can't say for sure. That's not what I recall at this time.
Did you bring your report with you?
No, sir.
Did you know you were going to be testifying about these statements today?
Not till about after 5 o'clock yesterday.
Fair enough. Do you recall Mr. Bryan being confused about the path of travel?
Yes, sir.
And in fact, you were confused about the path of travel, were you not?
Yes, sir.
Okay. So after you don't recall driving around for a while and having enough questions that you felt you needed to start it over?
I would say it's a possibility. I just don't recall the exact order of events.
Now, in terms of the broader climate, beyond what's going on in the neighborhood, the prosecution of Mr. Bryan was certainly looming, was it not?
As of
The specter of whether Mr. Bryan was going to be arrested had media from all across the country camped out in Brunswick.
As you and I discussed, I don't do what the media says. Whether or not he was to be arrested was solely a result of the investigation, and that investigation occurred over multiple weeks before he was arrested.
Do you remember multiple false statements, highly prejudicial to Mr. Bryan, circulating in the media in the time frame from May 11th to May 13th?
I didn't regularly track the media. We were pretty busy in the investigative process, so I'm sure they were out there, but I would not be able to recite them or be specific about them.
Do you recall having a conversation with Mr. Bryan about whether he had a gun at the time of the incident on February 23rd?
Yes, sir, I do.
And that was based on social media reports by people associated with the Arbery family that you could hear a gun being cocked on a video that they were discussing on social media. Do you recall that?
Yes, sir.
Okay. Do you recall these same people, or perhaps others not associated with them, putting out to the public that Mr. Bryan was a terrible person because he had taken a trophy or quote-unquote snuff video of Mr. Arbery's death?
I don't recall specifics. We had analysts that were monitoring social media news sites that were relaying information. So specifics I can't necessarily recall or provide to you.
Okay. Well, do you recall whether Mr. Bryan expressed concern about that?
About the video?
About the video and about his role in it and why it was taken.
Sure.
Because people were saying that he was taking this video like it was some kind of prize or trophy,
Yes,
as
sir.
opposed to being a witness.
Yes, sir.
Okay.
Do you recall there being a discussion in the media of a supposedly incriminating note found at a makeshift shrine at or near the shooting?
Your Honor, at this point, I'm going to object. We're now going on for about 5 minutes about what the media was out there and whether this agent recalls what the media had out there, which is not relevant to the voluntariness of Mr. Bryan's statements.
In French, au contraire. Part of what the court is considering, Your Honor, here today is not only whether there was a hope of benefit within the meaning of the statute, but also whether there was a fear of injury within the meaning of the statute. Now, if Ms. Dunikowski has some legal authority to say that it's legally irrelevant that Mr. Bryan was in fear, whether the police were intending to harm him or allow third parties to harm him, if there's a case that she can find, but the last I checked, the sum total of cases on fear of injury under Georgia law was 7 in 2008. It's probably slightly larger now, but this is a novel area of the law. So I think I'm entitled to some latitude here.
Yes, this would be the statute, which is 24-8-824, only voluntary confessions admissible. To make a confession admissible, it shall have been made voluntarily, without being induced by another, by the slightest hope of benefit or remotest fear of injury. So therefore, it's a question of whether this agent caused remotest fear of injury, not whether this person induced fear in and of himself by other third parties that have nothing to do with action by the state. Thank you.
And I think what she's done is successfully recite the statute, which is thankfully brief. But what she hasn't been able to articulate is any case law in support of her interpretation of that statute, Your Honor. And to put it in a still rare, but perhaps not unprecedented perspective, if you bring in a mobster to be interviewed, you don't have to threaten to break the mobster's legs. But if you go out and you put out information that they're cooperating, you might not cause the injury, but you certainly induce the fear of it. And the question is going to be whether, in the context of this case, whether or not Mr. Bryan's statement was involuntary because he feared for injury and he was expecting the GBI to do something about it. But we'll get there. We're not done with the questioning. But we don't get to, the state wants to rule out the whole line of questioning without any legal authority that it's not relevant.
Well, we're going to narrow this down, because I asked this witness questions which he has direct knowledge of.
Yes, Your Honor.
Okay, that have to do with this. And they, so, but as far as, and unless you plan on putting your client up and explaining what that fear of injury might be, you're asking this witness to testify to what might have been your client's fear of injury. Is that correct?
That's right.
Okay. We need to move past this then.
Okay, I'll rephrase. Did Mr. Bryan express concern that people were saying he conspired with the McMichaels to kill Mr. Arbery?
Yes, sir.
Which was based on social media reports saying that he conspired to kill Mr. Arbery. He expressed to you that was the reason he was concerned.
I don't remember the specifics of why he thought that, but I do remember there being different conversations like that.
Okay. And you do recall, were you present for the GBI press conference about the arrest of the McMichaels?
On the lawn in front of the DNR building?
Yes, sir.
Yes, sir, I was.
Okay. And the GBI director, shall we say, was ambiguous as to Mr. Bryan's status at the time?
Objection. Once again, relevancy and whether Vic Reynolds was ambiguous or not, that's up to Vic Reynolds to testify to.
That's the stand.
Do you recall a conversation in the presence of Mr. Bryan about the mother of Ahmaud Arbery, Wanda Cooper Jones?
What conversation?
Well, do you recall a conversation as to whether Mr. Bryan was going to be prosecuted because Wanda Cooper Jones and the Arbery family were demanding it, as reflected in social media?
I recall multiple conversations about what was going on in the media, and I remember multiple times advising that I don't control the media. and that the investigation is what ends with the final result of whether someone is arrested. But as to the impact of the media on our investigation and our fact-finding mission, that they were not involved in that part of it. But again, this was a repeated conversation that was brought up to me multiple times and was answered the same time, the same way every time.
Do you recall assuring Mr. Bryan in his presence that y'all had contact with Wanda Cooper Jones and that he shouldn't believe what he reads in the media?
I don't recall that.
You don't recall telling him that y'all had contact with her and y'all felt you could work with her?
I don't recall that.
You don't recall making any representation whatsoever as to whether the victim's family, if Mr. Bryan cooperated, would stop asking that he be arrested?
Mr. Goff, we had multiple conversations about what was being said in the media, what was happening around the town, what was being said by the director. And again, it was always about the safety and your concern about how he was being presented. And my response was always the same about our investigation being what's leading what's going to happen, not what the media is saying.
All right. So you were aware that Mr. Bryan hoped to be publicly cleared of involvement in this shooting?
Based off my conversations with you, yes, sir.
And you actively encouraged that hope?
No, sir, I did not. You yourself acknowledged that I was not at the pay grade level that can make that decision. And I also advised you that whatever request you had, I would be able to run it up my chain of command. So we both were aware that I could not make that decision on my own.
Do you recall being asked more than once, where was the prosecuting attorney that was handling this, that was advising the GBI?
Yes, I remember you asking that multiple times and trying to touch base with the prosecuting attorney.
Do you remember saying that they were tied up?
I probably did.
Okay. Do you remember my inquiring why they weren't returning phone calls?
I remember conversations about the prosecuting attorney, but again, I was not in contact with the prosecuting attorney myself, so I would not have a lot of information to give you other than the GBI is investigating and that they are getting advised by the prosecuting attorney, but I was not in contact with that person myself.
Do you recall telling Ronnie Bryan that you personally did not believe that he was a target of this investigation?
I don't believe those were my words.
Do you recall telling him the problem was that the GBI director and the DA were uncomfortable at that time saying publicly that Ronnie Bryan was just a witness?
That was towards the end of our interviews, and that was after the time that you had scheduled a press conference without us knowing about it.
Without you knowing about it? Okay. Do you recall joking with Mr. Bryan in your vehicle before turning on the recording device that the video was made with, when Mr. Bryan asked you yet again whether you are going to prosecute him or not?
No, sir.
You don't recall looking back at the other officer in the car and laughing about it like it was silly?
No, sir.
Okay. And you never did anything to reassure Mr. Bryan that if he cooperated with you and told you the truth, never at any time did you suggest to him that he would not be prosecuted?
No, sir.
And you didn't make any similar representations to Mr. Bryan's fiancée, Amy Elrod?
No, sir.
Your Honor, I think opposing counsel's already seen what I've marked as Exhibit 1. It was attached to the motion filed earlier in the case that was the subject of the amendment to the omnibus motion. And copy for the court.
Yes, I've seen this, I'm aware of it.
Very well. May I approach the witness?
Yes.
Mr. Seacrest, I show you up. Do you have the blue ink on yours?
I do.
Sir, I show you what's been marked for identification purposes as Exhibit 1. directing your attention to what purports to be a text of May 13, 2020 at 7:59 p.m. Is that your text to Mr. Bryan's attorney?
It is.
Okay. And that is in response to the text that appears above it. Am I correct?
That's correct.
And you received the text above it?
Yes, sir.
Okay. And it's, you've texted myself and asked, can I call you later?
That's in response to a phone call of you calling me.
Okay. And the response was yes, looking for an ETA on an announcement.
That's right, that's your text.
And basically, your testimony today, it was just a figment of my imagination that there was an announcement coming. That you did nothing to suggest in any way that that was going to happen.
Like I said earlier, what I said I would do is run it up the chain of command, because as you and I both agreed, it was not within my ability to make that call.
And in response, you said, thanks, Kevin, I'll have an update soon.
That's correct.
And then you asked me to meet you, and you asked whether I was still in Brunswick.
That's correct.
Okay. And then, do I recall correctly that I explained to you that CNN and all these other news crews were parked in my front yard?
Yes, sir.
On St. Simon's?
Yes, sir.
Okay. And then someone suggested meeting at Starbucks on St. Simon's.
I'm unfamiliar with St. Simon's, so a suggestion from Starbucks would not have come from me.
Okay. But it was your suggestion to me.
It was.
Okay. Well, what was there to meet about other than the GBI announcing that Mr. Bryan was a witness and not a target of this investigation, not a subject of this investigation, a witness and not a potential defendant? What other purpose was there to meet that night?
It would be me following up and doing as I said I would do, which is to run it up my chain of command and see what their thoughts were on it. So this was my opportunity to sit down with you again to tell you what that decision was, in person rather than over the phone.
And then you then subsequently called and said you didn't want to meet at all.
That's correct.
Okay. And what's your recollection of that conversation?
Just that we had decided not to meet. The presence of the press was beginning to be kind of a, what I would call a little bit of a media circus, and we wanted to avoid that.
All right. Well, let me ask you this. You didn't recall expressing concern about Mr. Bryan releasing the results of his polygraph examination?
No, sir.
You've never at any time expressed concern about Mr. Bryan doing so?
The one time I recall our discussion, you and I talking about that, was just as it related to whether it would delay the pre-planned meeting that we had for the interview.
You don't recall saying that your bosses were quote-unquote spooked by the idea of Mr. Bryan releasing the polygraph results?
It was not about the polygraph results. It was your handling of the media.
Did you say that you didn't want to meet and that your bosses were spooked by the idea of Mr. Bryan disclosing the results of his polygraph, the exculpatory results of his polygraph?
I just answered that it was more about your handling of the media and the media circus that it was creating.
So essentially, what you were doing is, on behalf of the GBI, you persuaded Mr. Bryan not to defend himself in the court of public opinion for 5 days, specifically not to release the GBI polygraph results while Mr. Bryan is being crushed in the court of public opinion.
First, it was not a GBI polygraph, it was a private polygraph. Second off, I told you multiple times, I can't control what you do with the media. That is your decision.
So, all right, you didn't, so what you're saying is that you never asked that Mr. Bryan withhold the results of his polygraph examination to give the GBI an opportunity to make a public statement first.
Not to make a public statement. The only time I remember having that discussion about the polygraph was as it related to our schedule to be able to have that interview.
And were you copied with an email that went to Joyette Holmes and John Pursley and Vic Reynolds shortly after this meeting was canceled?
I was copied on several emails. I'm not sure which one you're referring to.
Okay. wanting to know when Mr. Bryan could release publicly the results of his polygraph examination?
Again, I was copied on several emails. I don't remember the specifics of them, as I hadn't really prepared to review them for this hearing.
Your Honor, I have no further questions for the witness. I would tender State's Exhibit 1.
State's Exhibit 1?
Yeah, the page with the text on it. Officer Sechrist, do you still have the original with the blue print on the bottom?
Yes, sir.
All right.
Thank you.
Thank you, sir.
You're welcome.
Your Honor, at this time, we would tender State's Exhibit 1.
I-
Defendant Exhibit 1.
Are we on Exhibit 1?
Defendant Exhibit 1.
I'm just making sure. Is there another Defendant Exhibit 1?
There is.
Yeah. So let's call this something different, because we already have a Defendant's Exhibit 1 from earlier in the proceedings.
From a different hearing.
Well, we're trying to keep all of the
I'm-
evidence. If we keep calling things 1, we'll get turned around.
Your Honor, I'm sorry. I was thinking of numbering each exhibit for each hearing. I apologize.
Yeah, so
Two.
let's call this
8.
8.
May I suggest 110? I think that's far enough out. If we just add a 10 to the one that's already on there?
Let's think about this for a second. We've been doing just state and defendants, right? Not otherwise marked. So this can be Bryan Jackson Deno, Exhibit 1. Okay?
Your Honor, if I could have a moment with my client.
Yeah.
Your Honor, we have no further questions for this witness. Thank you, Officer Sechrist.
Thank you.
Any redirect from the state?
None from the state, thank you.
Thank you. Next up, thank you. Was he under subpoena or just voluntarily?
He's voluntarily here.
Any additional witnesses on the just
None from the state, Your Honor.
None from the defense.
and this is going to be submitted to the court once the transcript is made available, correct? So I have 10 days from the transcript,
10 business days, correct.
10 business days from the date the May 11th transcript is provided to Mr. Gall.
Yes, Judge.
All right. All right, I have a Giglio motion filed by Travis and Gregory McMichael. Just so we're clear, filed December 31st, marked as 1.15.
Yes, Your Honor. We have talked to the state. We understand from speaking to, I don't remember, who- it was either Mr. Evans or Mr. Nikoski, that there are no deals with any witnesses, any co-defendants. And so at this point, there is nothing, according to the state, to reveal. We would ask that this motion be of a continuing nature And if there is a deal with any witnesses or defendants, that deals would be made available to the defense at that time?
There's a continuing obligation. The court recognizes that, and we expect the state to comply with that.
Yes, Your Honor.
Thank you, Your Honor.
All right. And then there is a Brady motion also filed by Gregory and Travis McMichael.
Thank you, Your Honor. This Brady motion is filed on behalf of Greg and Travis McMichael. I begin, you see that the Brady motion lays out a number of specifically articulated items that we seek. I'd like to begin by eliminating a number of them because we've had a response from the state that satisfies us with respect to some. And then I would like to address the state's obligation to provide us the remaining documents. The first paragraph, which begins on paragraph 2 of the Brady motion, A, all the videos collected by the Glynn County Sheriff's Office. The state has indicated that they've completed that work and provided those to us, and I'm satisfied with that response. For B, the body cam and patrol videos regarding the investigation on February 11th, the state has indicated that they've provided that as well. C, the communications that we sought there, we are withdrawing. D, a copy of all of the records maintained by the Civil Rights Division of the Department of Justice. At this point, Your Honor, I wish it's no longer an ongoing investigation as well, but these are the documents that we would like to argue the government is responsible for providing to the state so that they can provide to us. Same with E, all the records maintained by the Federal Bureau of Investigation relating to this offense. F, a copy of all the records maintained by the United States Attorney's Office for the Southern District of Georgia. Now they've been indicted in federal court, and that case is no longer an ongoing investigation, but instead is now an indicted offense, and I would include those as well in the items that the state has an obligation to provide to us. G, all the documents related, and we list them to Ahmaud Arbery's background. We have been told by the state that they've provided to us all that they have, and we are satisfied with that response.
You said that's G?
That was G. H, we are withdrawing because of I, which we sought a copy of any ante-litem notice that had been filed on behalf of the Arbery family. There is now a civil lawsuit that was filed on February 23rd, 2021, so that provides us the information that we needed in response to that item.
So I is also addressed?
It is. J, the contents of telephone records and social media accounts. The state has indicated that, to their knowledge, there were no telephone records related to Ahmaud Arbery, and that they have nor social media account information. So at this point, we are satisfied with their statement with regard to those items. But it is the state's position with respect to the remaining items that we sought and didn't get. Those items relating to the Department of Justice investigation, those items relating to the prosecution and investigation by the Southern District of Georgia, then resulting in the indicted offense now that's pending in the Southern District of Georgia, and any investigatory body concerned with the FBI and the Department of Justice. It was the state's position in their response, by relying on Kiles versus Whitley, that the prosecutor does have an obligation to learn of favorable evidence known to others and acting on the government's behalf in the case. And they say to the court in their response, we are aware of our obligation. It is their interpretation of relying on Zant versus Moon.
You're going to touch feedback. You may want to just pull that microphone away from
Okay.
that.
Is that better? Relying on Zant versus Moon, that acting on the government's behalf has been interpreted to mean that it refers to only those people over whom the prosecutor has authority. And they rely on the case in their response of United States versus Luis Gonzalez, saying that the prosecutor has no obligation to seek evidence which is not in their possession or of which it has no knowledge. Well, the Luis Gonzalez case, Your Honor, involved the boarding of a vessel by a Coast Guard operator and the discovery of a large quantity of marijuana on that vessel. They were charged, the captain and the crew were charged with a conspiracy to distribute marijuana. The captain of the vessel cut a deal and testified against a number of the members of the crew of that vessel. The government was ordered, pursuant to a proper Brady request, to provide all evidence favorable to the defendant. In response, the government had provided each of the appellants with a copy of an FBI rap sheet for the captain. And it represented that it understood that that rap sheet contained the full extent of the captain's criminal history. But after the convictions, it was discovered that the rap sheet didn't reflect 2 misdemeanor convictions that this vessel captain had in Florida. These misdemeanors would have constituted, the appellants argued, additional information they could have used to have impeached the captain of the vessel who testified against the rest of the crew. What the appellate court decided, the 11th Circuit decided in Luis Gonzalez, is that because there was no allegation that the government attorneys had any knowledge of those additional misdemeanor charges, they had no obligation to follow through and go any further than they did. No suggestion that they knew about it and had kept it from the appellants in the case. But relying on Luis Gonzalez completely misses the obligation and mischaracterizes the duties and responsibilities under the Fair Administration of Justice for the District Attorney's Office. The District Attorney's Office does not actually have, I'm not asserting that they actually have the U.S. Department of Justice Civil Rights Division file, nor am I asserting that they actually have the file, investigative and preparatory documents from the U.S. Attorney's Office in preparing and presenting their information for the indictment. But they constructively possess things that the defendant cannot otherwise get. And not because they have the authority over the Department of Justice or the United States Attorney's Office, but because they have knowledge of and access to those documents based upon their partnership in investigating and prosecuting the McMichaels for the circumstances surrounding Ahmaud Arbery's death. How do we know that there's a partnership? I'm now placing on the smartboard the press release that the court is familiar with. It's a document relied upon, presented to the court during Greg and Travis McMichael's bond hearing, and it was relied upon expressly by this court in the bond order denying bond for those defendants. And it begins, the Civil Rights Division of the Department of Justice, the FBI, and the U.S. Attorney for the Southern District of Georgia have been supporting and will continue fully to support and participate in the state investigation. And that was prepared and presented by the Department of Justice spokesperson Carrie Kupek. I will tender, so that we can keep our exhibits straight for each hearing, I'd like to tender that exhibit as defense exhibit number 39.
No objection.
Submitted.
Your Honor, it didn't end with that. There are a number of other exhibits, and I've marked them, beginning with the number, defendant's exhibit number 30, or exhibit number 40, and going forward, 16 exhibits. And these all relate to GBI investigative summaries that note their cooperation with the FBI or the FBI's cooperation with the GBI or the District Attorney's Office. So I would now tender defendants exhibits 40A, though I have to perfect the record, it appears that one is missing in the copy, through 40N. And I can summarize those for the courts. I would like to just give you some idea of what we're talking about.
Judge, at this time we object. We acknowledge that, you know, these are in dispute. We saw Ms. Hoag's motion, and this is a GBI report, Judge. We don't think it's proper to tender in a GBI report. It would be hearsay.
Did you need me to respond to that?
Yeah.
It is not hearsay with respect to the issue before this court. The issue before this court is whether these reports evidence a relationship between the various agents of various organizations, some of whom are the Georgia Bureau of Investigation, that this court would not hesitate to say that the District Attorney's Office must provide their reports to me. But when you see that the Georgia Bureau of Investigation lead agents are working with the FBI and the FBI is providing information to them from the US DOJ Civil Rights Division investigation, that information is no longer hearsay. I can't imagine that the District Attorney's Office is saying that they do not agree with the accuracy or validity or truth of the GBI reports by their chief agent in this case to us.
Whose reports are these and what are they?
I'll go through and summarize them for you, Your Honor. Exhibit 3, which is dated May 6th, 2020, is a report prepared by the lead investigator, Agent Dial, and his contact with FBI Special Agent Jeff Roberts. Agent Roberts from the FBI says that the FBI knows...
Objection, Your Honor. I would object to her reading this into the record. I mean, it's not an evidence. We're objecting to it.
I don't have a problem with the existence of the report. It's just what's contained in the report. That's the objection. And because it's an objection, I've got to address then what is contained in the report.
Exactly, and that's why I have to tell you that it's indicating that there is a discussion between these agencies about the assistance that each will give to the other.
We don't know what that is.
Well, I do. I'm looking at the report, and I can provide them up to the court. I can put this motion on hold and call these agents, but I can imagine that each of them would say, yeah, what I wrote there is true. And I'm just kind of muffled. I can't figure out why the District Attorney's Office would say, we don't know that that's true.
And Judge, we're not disputing that the FBI played a role in the case. I mean, it's there. They did help the GBI. We're not disputing that.
All right.
They do have a federal case pending, so we don't dispute that.
Yeah, I mean, it's, in fact, 2 days ago, the defendants appeared in federal court on these charges.
Exactly.
So, I mean,
Let me go to the
really
case
question,
law.
as I understand it, and the question is, you're trying to get the federal investigative files through the district attorney's office.
Yes, Your Honor.
In this case, if there are investigative files in the Southern District, aren't they available through the Southern District and the indictment of the Southern District?
The discovery is not available to me, Your Honor. I do not represent Greg McMichael in the Southern District of Georgia. They've been appointed different
I
counsel.
understand that different counsel. The client is entitled to it in the Southern District.
He will certainly be entitled to it.
So let's assume there was a relationship between GBI and the FBI. It sounds like there's no dispute about that, and there's press releases and documents indicating that there had been some coordination. Anything that got generated that the state has in its possession that would be required to be disclosed under Brady, I assume is disclosed. If it's not, then if that then comes to the court's attention, then that becomes a real issue because that's an ongoing obligation of the state.
Your Honor, it is. We've disclosed everything that's in our possession.
And this is where the wrinkle is, Your Honor. That mischaracterizes their burden. I'd like to provide case law to you that characterizes the burden of the district attorney in a criminal case as being much wider than the notion of whether you put that document into the district attorney's file. The Otten case makes very clear that what you choose to look for and put in your file as a prosecutor is not the whole part and parcel of the discovery obligation under Brady. In Otten, the district attorney made a deal at the last minute with an agent, with a witness in the case, with a defendant, and he cooperated. And the prosecutor, because of shortness of time, didn't run the FBI or NCIC check on the witness, something that a defense lawyer could do themselves. Their not having gone to look for something does not change known information into unknown information, simply because they chose not to look for it. And I'm responding to the district attorney's assertion in their response that they don't have any knowledge of evidence that's contained within the Department of Justice or FBI files. And I quote from Otten, "The basic import of Brady is that there's an obligation on the part of the prosecution to produce certain evidence," and I quote, "actually or constructively in its possession or accessible to it in the interest of inherent fairness." Brady says if it's available to the prosecutor in order to promote the fair administration of justice.
Yeah, hold on a second, because first, I don't like the characterization of the court addressing Brady. More importantly, give me a case that tells me that a state has whatever authority you think the state does to go to the federal government and pull those files out. That's really the crux of it here.
I will, Your Honor.
Because, you know, again, particularly in a situation where the defendants are indicted in federal court and have access to all of the information that is available in federal court.
Your Honor, the defendant will inevitably have access to all of that information. The defendant has no idea, however, when he will get it, and we're on a trial calendar. The state of Georgia cannot pretend, as it says in the end of its response, that there may have been a purposeful reason for not getting access to some of these documents. What the exhibits that I was about to tender earlier reflect, Your Honor, is a give and take between these agencies. So when the FBI has incriminating information that assisted the district attorney's office in preparing for prosecution or for trial, the FBI is providing it to the district attorney's office. The FBI is not providing exculpatory information to the district attorney's office because that would then put that information no longer constructively, but actually in their possession. And so I do have a case, Your Honor, that makes it very clear. The case of United States versus Antone. Relying on the principles in the Deutsch case, D-E-U-T-S-C-H. In that case, the government the prosecution was denying having access to the file because it didn't have it in its present physical possession. But what this court discovered through the Trevino case, and relying on that with respect to the post office cases that Trevino and its progeny fall from, is that what they were doing is not seeking the information from the agencies that would do anything but propel forward the prosecutor's own case without seeking the entire file. And I quote here, they declined to draw a distinction between different agencies under the same government, focusing instead upon a prosecution team, which involves both investigative and prosecutorial personnel. Certainly, the case law says, the Fifth Circuit demands, the prosecutor would not be allowed to avoid disclosure of evidence by the simple expedient of leaving relevant evidence to repose in the hands of another agency while utilizing his access to those parts of it that he wants in preparing his case for trial. The district attorney's response in the final paragraph says, some of this information may be purposefully, and they may be purposefully and intentionally excluded from other investigations and prosecutions, which does not make any sense to me. What the Deutsch case says, that follows from the cases that I've cited to the court, is this, Your Honor. It is troubling with respect to the fair administration of justice for the district attorney's office to know that a cooperating partner has exculpatory evidence but does not ask for it to be given to that state agency for the purpose of making it undiscoverable. So yes, Your Honor, in the big scheme of things, it is possible that in enough time we may get access to Greg's copy of the file. However, Greg's copy of the file is Greg's copy of the file. What we're saying here is, and what Deutsch makes clear, not only does this prosecutorial body in U.S. versus Deutsch deny that they had access, they say you didn't even attempt to remedy that. You agree that you worked in many ways in partnership. The FBI gave you stuff, you gave stuff to the Department of Justice, you guys told each other about what you found, what you were looking for, we helped you, the FBI helped them execute search warrants, the FBI looked for Facebook information that this court's aware of. There's no suggestion in Brady, the Deutsch case says, that different arms of the government, particularly when so closely connected, are severable entities. It simply just does not allow for the fair administration of justice if the state of Georgia, through the district attorney's office, knows of witnesses who they have on their witness list who were presented with subpoenas for the federal grand jury, testified to information that we have reason to believe is exculpatory.
So you're suggesting the federal government is suppressing exculpatory information or not providing it to the state, so it doesn't need to be produced in this case under Brady?
No, sir. I'm suggesting that the district attorney's office has no obligation, they say, to go get a file from a different agency. But what these cases say...
If they're aware of exculpatory information, wouldn't they have an obligation?
Yes, they would.
Okay.
They say they have no knowledge and they have no access to that file. And I say, respectfully, If you can ask the FBI or the DOJ to give you their Facebook information, if you can ask them to come help you canvass neighborhoods to interview witnesses or serve search warrants, then you can ask them, hey, I've got 97 witnesses on my witness list. Did any of these folks testify before the federal grand jury? I'd like a copy of that transcript. So with that, it sounds as if the state is conceding the kind of partnership that I'm describing, and if they don't, then I will have to leave the record open. I'm aghast that they wouldn't accept the GBI reports. And Your Honor, I don't see this as hearsay. I'm not offering it for the truth of the matter asserted. Perhaps it's not true. Then we've got much bigger problems. But I don't think they're saying it's not true. I'm saying it's reflecting the extent and the length of time and the sorts of things that these agencies were doing with each other, all for the same purpose, for the investigation and prosecution of Greg and Travis McMichael for the circumstances surrounding Ahmaud Arbery's death. And for that reason, they have an obligation to go out and get that stuff, because for practical purposes, they do have access to it with probably a phone call.
1 second.
Your Honor, the defense cites to some federal cases. I actually am going to point the court to a Georgia case. It's a Georgia Court of Appeals case, Ferguson v. State, 226 Georgia App 681. It's a 1997 case. In that case, there was this partnership between the FBI and DeKalb County PD. And the court there held that prosecutors have a duty to learn of any favorable evidence known to the others acting on the government's behalf in a given case. We don't disagree with that, which means person over whom the prosecutor has authority. That's the main focus here. Do we have authority over the FBI? Can we really commandeer the Department of Justice and the FBI and say, hand over your file? We cannot do that. The court in Ferguson went on to say this, and I quote, even though there was some degree of cooperation between the FBI and the county police, there was no evidence that the FBI or any of its agents worked for or was subject to the control or authority of the state prosecutor. And that is what we have here. We have two separate entities, the DA's office, and we have the Department of Justice and the FBI, and we have absolutely no control over their case, their investigation, or their evidence. And the Georgia case law is clear on that. I think what the defense is trying to argue is that because it might be more accessible to the state, then they're under no obligation to try for themselves. I also want to point the court to Ballard v. State, 297 Georgia 248. That's a 2015 Georgia Supreme Court case. And essentially the court in that case held, and I quote, Brady does not impose an affirmative obligation on the prosecution to seek out information for the defense, even if such information is more accessible to the prosecution than to the defense. So we don't have an obligation to do this simply because it might be more accessible to us. The defense has that obligation themselves. It's accessible to the defense, as the court already pointed out. And we do not have access to their grand jury testimony. We were not present in the grand jury proceeding. As the court's aware, the grand jury is a secret proceeding, and we were not there. We don't know who testified. Also, another case, a Georgia Appeals Court case, Gann, Gann v. State, 166, Georgia App 172. It's a 1983 case. There, the court held that where the defendant filed a Brady motion requesting certain records of a victim that the state did not possess, the court there held that the state was not required to actively seek out the records not in its possession. There is no proof that we have told the FBI not to send us certain things just because we think that they might help the defense's case. We have not told the FBI to conceal evidence from us. That's just a bare assertion with absolutely no proof on the part of the defense's motion. And we don't know that the FBI have any exculpatory evidence or any evidence that Brady would require us to turn over. We absolutely have no knowledge of that. So, Judge, just given the Georgia law directly on point in Ferguson v. the state, we would ask for the court to deny the motion to provide all this stuff that we simply do not have. And we have not violated our Brady obligations in any way. And of course, we know our continuing duty under Brady, and we will definitely turn over anything that is required by Brady as it becomes, as it comes into our possession. Right now, we don't have it.
Your Honor, the cases that I've provided to the court say you can't make this decision without asking the state, have you tried and been denied access? It is statutorily incorrect to say that we have equal access to those documents. The court's aware I can't subpoena a federal employee. I'd need to go through a TUI hearing, and they're not going to provide any information in open cases to a person that's not representing that individual in that case. I am imputing no ill will on the district attorney's office. I'm saying they have a clear sense in their mind that if that agency doesn't work for us, we don't have to get the stuff. And I'm saying these cases say otherwise. They make it clear that you can't just say, I don't have it, when you know it is available there with an agency that's been a partner with you, as displayed to the rest of the world in the press release, a partner with you on the things that you do need. So if they have not asked for statements at the grand jury of the witnesses they intend to introduce at trial or that are on the witness list, then they have not fulfilled their obligation under Brady if they haven't asked their partner in this investigation, because that means they have access to it, unless that agency were to say, I can't imagine why, but forget it, we're not giving it to you, even though every other thing we've cooperated on in putting together this state murder case, and it appears a federal hate crime investigation leading now to an indictment. There's just too much that overlaps here, Your Honor, and it went on from the time that the Georgia Bureau of Investigations came on the case all the way through. The last report I saw was in November of 2020. Each of them helping each other and continuing, as that press release says, to be there for each other and to assist in each of their cases.
All right, well,
Your Honor, as we have a number of Brady requests pending, I do want to add another perspective to this motion for your court, Your Honor, to consider. We're deeply concerned, along with the McMichael defendants, about the way this supposedly concurrent investigation has been conducted. No allegations of wrongdoing at this time, but there's a practical concern, Your Honor. I represent Ronnie Bryan. I don't have a law firm and a bunch of investigators and unlimited resources to go do Mr. Bryan's work. It's just me. And if we're going to have all kinds of last-minute disclosures, directly or indirectly, that force Mr. Bryan to seek a continuance, we can't be forced to choose between a fair trial and a speedy trial. I just putting the state on notice. that there are going to be complications. If there's a big dump and it turns of documents or other evidence in this case, and it turns out the state could have obtained it and didn't even try, that's going to factor into a number of other motions.
That's why we have a scheduling order in place. So I was familiar with the scheduling order, and that scheduling order required that things be produced and motions be filed, and unless good cause is shown, we're sticking to a scheduling order and we have a trial date. So that's just a reminder to everybody that I plan on bringing in at least the first panel of jury selection on October 18th. I have been working with the Superior Court here in Glenn County to see if I can at least get one more day prior to trial, probably at least one day prior to trial, to follow up on potentially bifurcated matters, as well as just make sure that we are clean with respect to motions that are before the court. I believe I've addressed now all of the matters that I noticed for the hearing over these 2 days. There are a couple of other matters that are sitting out there. What I'm going to ask the parties to do is go ahead and send me, or through Ms. Carney, send an email that just notes whatever motions you believe still need to be heard by the court, other than motions to eliminate, things that we can simply take care of just before the trial of the case. And I'll go ahead and, from a scheduling standpoint, see if we can work those out. As to the Brady matter, I'll take a look at the cases. I took a quick look at the partnership case that was referred to. I started reading through it. I need to get to the details of that. That looked actually, from a factual standpoint, like an interesting case to read through, because there seemed to be quite a lot to it. But I'll have to look at that as well as the matters cited by the state.
Your Honor, for the record, purpose of the record is the state's hearsay objection to the exhibits that I tendered. Has that been sustained for purposes of hearsay? That was the
objection. What I understand is we're trying to get in whatever the contents of those reports are.
I take exception to the ruling.
All right. As I said, I'll go one at a time. I've addressed all of the matters I had on my notice, as well as the holdovers that I've noted throughout the last day or so. Anything further from the state?
Nothing further from the state now.
From Travis?
Yes, Your Honor, just briefly. In the briefing schedule that the court is allowing, because our motion on 404B was to admit, I believe you gave the state 20 days following the submission of our brief. I'd like to ask for that same consideration on the state's motion in limine to prevent the mental illness history, so that we would be able to follow their brief within 20 days.
That makes sense.
Thank you, Judge.
And Your Honor, I actually have a problem with that. And the problem is, I still don't know the basis of relevancy for the relevancy motion on mental health. In other words, I can't respond. I'm going to write a brief that says it's not relevant because I don't know what the relevancy is. They're going to write a brief that says this is relevant, and then I'm going to write a third brief in response to that once I figure out what their assertion of relevance is. So I'm kind of left at a disadvantage. I understand that I filed the 405 to keep out the victim's character. Mr. Sheffield has now characterized his brief as not a 405 character brief, but as a 401 relevancy brief. So at this point, I think it's his motion, so I would like for him to at least let me know what the relevance is.
I guess the issue too, I need to know that. Well, we've got the documents that are before the court when they're going to be submitted. Now, let's do that. I'll allow a schedule where the state files, defense files, the state needs to follow up, then I'll allow the state to follow up on that. That's fine.
As we understand, what Your Honor is asking for is an initial foot into the deep water here to try to understand mental illness, its place in a case, how it may be relevant, what it speaks to. Reading the Vermont case that Your Honor talked about previously goes into a lot of detail about that and the interplay between 401 and 403 and 404 and 405. So it seems that you want to deal with those issues as a matter of trying to understand, should we even go further by having the testimony? Meaning, should we even be talking about mental illness in a court? We're allowed to get into those privileged documents.
The question, under what circumstances could this evidence
Absolutely.
possibly make it into this trial?
So that we address the relevancy issue, which is 401, which is, I'm not trying to uncharacterize the state's motion in limine, but I heard that's what the court was asking for.
So the motions in limine were very plain.
Okay.
Okay. So it really didn't get into any of this. So what I'm asking for is, now that you've gotten up and told me what you plan to do, and now that I understand what the state's concerns are, and given the fact that this is, I don't want to say completely uncharted waters, but it's a novel approach, particularly in Georgia, someone's going to need to walk me through this evidence and tell me how it gets in a case like this.
Sure.
Particularly given the various issues that layer over it. And I mean, just walk me through it. I want it on paper, and I want to know what evidence we're planning to get in to show this, what you claim to be relevant evidence.
With pleasure. We'll do it.
That's what I'm looking for. So I don't want anybody to overthink it. Again, when it comes to trying cases, to me, sometimes we overthink things. Let's be practical about it. What are the rules of evidence? How are we going to use them? What's the evidence we're trying to get in? Explain it to me. Walk me through it.
Sure.
That's all I'm looking for. All right. Anything further than from Travis McMichael?
Nothing further.
From Gregory McMichael.
Your Honor, those were the only two briefs that I recall, right?
Those, I think Mr. Bryan, I'm expecting something on the statement, and then the state's going to produce within 10 days any emails between the state, the Cobb County District Attorney's Office, and the defendant.
All right. Thank you.
All right, so beyond that.
I actually have that to-do list, but I also have that on the 404B. You also wanted an additional brief for both the defense and the state. So for the defendants, 404B, they were going to do a brief, and I was going to have 20 days to respond to that. Their 401, they were going to do a brief, 20 days to respond to that, and I was going to do the Jackson Deno and provide the Greg McMichael communications, if any.
401, they're going to, and then we're going to respond.
Yes.
Well,
Oh,
it's-
no, thinking about it, no, because you're asking for the evidence to come in. I want to know how that evidence gets in, and the state gets to respond.
Okay.
And explain what the objections might be to that.
Sure.
So now I understand what you're saying. That's, I need something from you. It's your evidence.
Sure.
Maybe their motion initially, but it's your evidence you're wanting to get in.
Absolutely, it's fine.
Your Honor, if I may ask, we stagger those a little bit, like maybe a 20 and a 30. Looking ahead at my calendar, you want those two substantial issues briefed in 20 days. I'll do it, or we'll do it, but if we could just do a 20 and a 30, and I don't care which gets more time, would that work for the court?
If anybody has any objection to that,
No objection.
all right, that's fine. So within 20 days, we will have the,
Something.
no, something's not a good answer.
We'll do,
404B.
404B in 30 days,
10 more days after that.
10, 30 days,
30 days.
401.
401.
Yes, sir.
Your Honor, I think my question is pretty simple. You've indicated that we're going to select jury and panels beginning on the date set in October. Statutorily, for what it's worth, I think the defendants all have a right to ask for panels of 12. I think there's case law is less than clear on what that actually means. But given the situation, I thought it fair to require when we're going to seat panels, we're going to seat 12 in the morning and 12 in the afternoon, or what did the court have in mind?
The plan is to go ahead, unless somebody's going to object, to go ahead and start with the using as many seats as we can in the jury assembly room here in the.
Well, I will confirm, Your Honor, but that could be like 150 people at once. That would be, every judge in this circuit has their own way of seating jurors for jury selection, which is why I've learned the hard way. If we could get a schematic from the court as to how it wants to seat the jurors, and which right to left, left to right, so that we don't end up in a situation where there's confusion as to who's seated where and how many people were seated.
Your Honor, I understood earlier today that we were going to have one more time and be together, and you would accept from the defense a suggestion, a hope, some thoughts about the logistics from panels, what issues are going to be handled individually, what the order of it is, all those sorts of things. So if we could do that, put that together and have that ready for you, certainly well in advance of the next time we have hearings, we could probably flesh all these things out, along with the potential juror questionnaire.
It's going to happen in reverse. The court's going to be telling y'all how I intend to do it, because we have logistics issues. I have a lot of things that I've got to deal with here in Glenn County. So with all due respect, there's going to be a way that we're going to be able to do this in Glenn County. I will let y'all know what that's going to be. If there's an objection legally, then I'll go ahead and address the legal objection. But this isn't going to be a conference call on jury selection. It's just not going to work that way. The court needs to work through a number of things. As you all know, this is not my regular courthouse. And so the communication needs to be very clear as far in advance as possible from my office to Glenn County about how we're going to do this. And so this is going to be approached that way. So once we look at it, if there's a way to tweak it, fine. I'm going to put a plan in place, and we're going to try to execute that plan unless legally there's some barrier to doing so.
And I would like to let you know that in light of what Mr. Goff just said about panels of 12, we would invoke OCGA 15-12-131.
Let's do it for, if you're going to invoke it, do it formally. Put it on notice.
We'll do it.
All right. Understand those are all the matters that are before the court. We are in recess, and I'll provide notice on another date of it.
All rise.
Gotta work through the.
So the exhibits, it was going to be